Welcome to Miranda versus Arizona. So, I know for the last few classes we've been dealing with a lot of the deep history behind constitutions, behind the United States Constitution and constitutional law, and law in general. So now we're going to be looking at one of the most interesting of the landmark Supreme Court cases, Miranda versus Arizona. So the case centers on a gentleman by the name of Ernesto Miranda, and I use the word gentleman all too loosely when describing this particular individual, as he was arrested for rape and kidnapping in Phoenix, Arizona in 1963. Now, Mr. Miranda confessed to the crimes and was convicted at a trial based upon this confession. While in prison, he filed an appeal. That is to say that he decided to file a petition with an appellate court arguing that his conviction was in violation of constitutional law. He argued that he was never informed of his Fifth Amendment right against self-incrimination, nor of his Sixth Amendment right to have an attorney present. Now, the Arizona appellate court disagreed and upheld the original conviction. However, the case eventually reached the Supreme Court by 1966. The Supreme Court ruled in favor of Miranda in this case. So the verdict. So they ruled that 1. The defendant must be informed of their Fifth Amendment right to protection against self-incrimination. That means against giving out. You're not required to answer any question that would give away evidence that you committed a crime. You also have their Sixth Amendment right to legal counsel, that is, to have a lawyer present. Now, the Supreme Court also ruled that police must inform the accused of these rights prior to questioning. So before they can question a suspect who's been arrested, they must first inform them of these rights and make sure that they understand these rights. Now, because this was not done in Ernesto Miranda's case, his confession was deemed to be illegally obtained, and his conviction was overturned. So, what were the outcomes? Well, in the short term, Ernesto Miranda was retried, and based upon other evidence, he was convicted of the crimes anyway. It's rather interesting because of all the cases that are often considered civil rights Supreme Court cases, this one is very interesting because the individual who suffered the injustice, that is to say, whose constitutional rights were violated, was in fact basically guilty as sin. He did actually kidnap and rape the people that he was accused of kidnapping and raping. It's just that the police did not do the initial trial the right way. He was denied his constitutional rights, and his confession was illegitimate. However, as later evidence proved, he did in fact commit the crime, which is very interesting. That is not the norm compared to other landmark civil rights cases. And that's one of the things I think is most fascinating about the Miranda versus Arizona case. Now, the more long-term consequence is that police became, at this point, it was stated that they were required to read defendants their rights prior to questioning. So this leads to the Miranda rights. So any individual who is arrested will be read something to this extent. You have informed that you have the right to remain silent, aka shut up. You do not have to tell the police anything. Then also that anything you say can and will be used against you in a court of law. It's letting them know that if, from this point onward, if you say anything after you've been informed that you have the right to remain silent, the police and the district attorney are allowed to use anything you said against you in court. You're also told at this point that you have the right to an attorney, so a lawyer can be present. And that if you cannot afford to hire a lawyer, one will be provided to you. You would then be asked if you were under arrest, and again, I hope none of you ever are, but if it were to happen, do you understand your rights? So if, let's say, you had a language barrier, so maybe you didn't speak English, or maybe you communicate only in American Sign Language, you can't hear, that would be the time to try to let the police know, at which point they are then supposed to find a translator of some sort to then read you your Miranda rights in a manner that you can understand. So, the right to an attorney. What this means is that you have the right to have a lawyer present for your interrogation. So if you are arrested, that means the police believe that you committed a crime. And the first thing they want to do is to question you to try to get evidence that you did commit this crime. You are allowed to have a lawyer present for this process, and it is highly recommended that you do so. Cops come a-knocking, you stop a-talking until you get that lawyer. Do not think that you can try this on your own. Cops can be very tricky. And lawyers know better what it is that they are and are not allowed to do, and can inform you of things such as that the police are allowed to lie during the course of an interrogation. They can tell you that they have evidence even if they don't actually have it. They can't lie at trial about the evidence, but they can tell you, oh, I have you doing that on videotape, hoping that then you'll confess. Your lawyer can better inform you as to whether or not this is the kind of question you should answer. It's also important to note other things that a lawyer can help you out with is, in many cases, a lawyer can simply shut the entire interrogation down. The lawyer may state that you're not talking at this point. And if the lawyer says you're done talking, then you're done talking. They cannot, once you request a lawyer, the police cannot question you until one is present, unless you expressly waive your right to an attorney. Now you can state that, yeah, I don't want a lawyer, I don't need a lawyer. Do this at your own peril. This is very dangerous, especially because many cops are quite sneaky. So I would not recommend this, even if you're innocent. That's a mistake that many innocent people who have been wrongfully convicted have made, is they assume, well, if I've done nothing wrong, I have nothing to hide. And unfortunately, that doesn't always protect people. Good legal counsel can better tell you what to do and what not to do to make sure that your rights are not violated. Now, if you cannot afford a lawyer, now, most of us aren't terribly rich, and lawyers tend to be very expensive, the court will appoint an attorney to you, but there are some things you should know about a court-appointed attorney. A public defender, which is the type of attorney that is appointed by the court, will in many cases not be the best lawyer out there. A lot of public defenders are law students fresh out of law school that often have either never tried a case or have tried a few cases. Because they don't have a lot of experience and are not associated with a major law firm, they often are not regularly sought out by people with a lot of money that are looking to hire a lawyer, but the court will be willing to pay them a very small fee in order to be a lawyer for someone who cannot afford one. Now, is this better than not having a lawyer at all? Yeah. Unless you have a law degree, someone with a law degree is still going to be a better bet than trying to wing it yourself. But generally, if your freedom is on the line, you're going to want a pretty good lawyer. Now, the right to remain silent. You cannot be compelled to testify against yourself, even at trial, if you choose to take the witness stand and the lawyer asks you outright, did you do something or didn't you do something? You are allowed to answer that you plead the fifth, meaning that you are invoking your constitutional right against self-incrimination. That to answer that question would involve you incriminating yourself. That's making yourself understood to be guilty of committing a crime. Now, this also extends to the fact that you are not required to tell the police anything, except maybe your name. That might be the one thing you might be required to tell them in some places. Now, there are some circumstances where you are required by law to present them with an ID. And a major example of this is driving. You're driving an automobile, and a cop pulls you over, then you have to tell them then you have to show them ID, because that pertains to your right to operate the motor vehicle. So in that case, you have to hand over ID. But you really don't have to talk to them too much. That's a big thing. A lot of people think that because policemen ask them a question that you automatically have to answer them. This also gets another interesting thing. You cannot get in trouble for not talking, but you can get in trouble for lying. This is one of those kind of messed up things about the court system. The police are allowed to lie to you, but you are not allowed to lie to the police, because that's considered misleading a criminal investigation. So as a result of this, even though the police can tell you 1,000 lies during the process of an interrogation to try to get a confession out of you, if you lie even once to throw them off track, even if they can't find any evidence that you actually committed the crime they brought you in for, they could still choose to throw at you the crime of lying to police or obstructing a criminal investigation. So as a result of this, you can get in trouble for lying. But since you can't get in any trouble for not saying anything, the best bet is just not to say anything. A lot of people think, oh, well, if I don't talk, then they're going to hassle me, and better for me to tell them something so they'll go away. While that may be the conventional wisdom and that may be the instinct, the problem is that's kind of how they get you. Because you can get in trouble for lying to them. If you lead them on a goose chase because you don't want them bothering you, so if you tell them something, anything to get them away, and it comes back to them or the district attorney that you lied, now just doing that, you've now committed a crime. If you say nothing, they got nothing on you. Best thing you can do, don't say anything. So that's been the Miranda rights. These are things you should remember. There's a lot of stuff that you learn in high school that not everyone is going to use on a regular basis. Some of you will use it, some of you won't. This is one of those things that just about every person coming out of high school needs to understand. Like at this very moment, you gentlemen are both over the age of 16. You are old enough that someone could try to try you as an adult, so you need to know what your legal rights are. The more of them you understand, the more equipped you are to protect your legal rights. So I hope you found this useful.